Hi, everybody. Welcome back. Last time, I argued that the transactions between the owners of Good Health, our steel plant's neighbors, and the steel plant itself over the transfer of that good health from the neighbors to the steel plant to be used to produce steel, that those transactions will typically not take place because they're blocked by a combination of transactions costs, primarily the transactions cost created by involuntariness, the technical ability of the steel plant to simply take the property right to good health and to use it to produce steel without bargaining with the owners of the good health themselves. In this lecture, I'd like to talk about solutions to this particular problem, to the problem of the failure of markets in good health to exist, and thus the persistence of externality relationships between the steel plant and the owners of the good health, the plant's neighbors. I'll talk about 4 such solutions, 2 of them in this lecture and 2 of them in the next lecture. These 4 are what I'll call absolute deterrence, tort liability, a tax, which I'll call the Pigovian tax, and finally, social norms. Let's talk about each of these in turn. Absolute deterrence means that there won't be any crud at all. We could attempt to deter the production of crud absolutely by simply passing a law that says that no crud may be tossed in the air, end of story. But of course, if we do that and ban the production of crud, under our hypotheses, we'll also ban the production of steel, because as we've assumed, steel can't be made without the production of some irreducible amount of crud. If the crud is banned, then no costs to good health are imposed at all. That is, the property right to good health stays with the plant's neighbors because the plant doesn't use it to make steel because no steel is being made. Thus, the costs to good health, or put another way, the taking of the property right to good health, which is initially placed in the plant's neighbors, are deterred absolutely, at least ideally. If the law works well, no steel will be produced and no crud will be produced as well. This may well be the efficient outcome if the neighbors are the higher valuing owners of the right to good health. So, indeed, if transactions between the neighbors and the steel plant were easy, and the steel plant was not the highest valuing owner of the rights to good health, that is, if the sum of the costs that the owners of good health would have to contribute to the production of steel is greater than the value of that good health to the steel plant for the production of steel, then the efficient outcome is that the property rights remain in the hands of the plant's neighbors, that the steel plant not have them, and that therefore steel not be made. But it may be the other way around. It may be that the production of steel does produce enough value to cover all the costs of production, including the costs to good health. And if that is the case, then banning crud is inefficient. That is to say, it stops the production of steel such that the steel would be more valuable than all of the resources that had to be contributed in order to produce that steel, including the contribution of the good health. Without exchanges, it's very, very hard to know who the highest valuing owner of a property right might be. So, if we simply ban the crud altogether, we take a chance by presuming that relationship to lie in one direction or another. If we ban the crud, that is, we might argue or interpret that as a statement, a presumption, if you will, that the plant is the lower valuing owner of the property rights in question, and thus that the property rights, for efficiency's sake, ought to stay with the owners, that is, with the plant's neighbors. But of course, that presupposition may be wrong. It may well be that free transactions would have transferred the property right from the original owners to the plant, and without free exchange, it is very difficult to know. A second possible solution to the market failure problem is tort liability. This means bringing the law and the courts into the solution of the externality problem that we've been describing. In a tort liability solution, we allow the neighbors, the owners of the property right to good health, to sue the steel plant for the plant's uncompensated taking of their rights. And if a jury finds first that the neighbors are the original owners of the property right, and that the steel plant has unlawfully taken that property right from them without consent or compensation, then the jury fixes an amount of compensation to be paid by the steel plant for the deprivation of the property rights that the plant's neighbors have suffered. So, tort liability means a tort. What's a tort? A tort is an unlawful act that does not rise to the level of a crime and for which compensation is due from the person who has committed the tort, called the tortfeasor, to the victim or the bearer of the costs of the tort. Torts are unlawful acts, which means that the law can take action against the people who take them. Torts are, in themselves, not crimes. Crimes typically include torts, but torts typically don't include crimes. Later in the course, we'll spend a good deal of time distinguishing between tort and crime, but for now, all we need to know is that torts are unlawful takings of property rights by individuals for which compensation in the form of damages are due. And in a tort suit, the job of the jury, as I've said, first is to decide whether the plaintiff's property right was in fact taken by the defendant unlawfully, and if so, what amount the defendant must pay the plaintiff in compensation for the value of the loss. Talking about tort liability in this way introduces a crucial concept that we'll be using many times later on in the course, and that's the notion of liability. So I'd like to take a digression and talk for a little bit about the problem of property and liability, and in doing so, I will draw on the groundbreaking work of two legal scholars, Guido Calabresi, a professor of law at Yale Law School and later a judge, like Judge Posner, in the Federal Appeals Court in Judge Calabresi's case for the Second Federal Circuit, and in an article that Judge Calabresi wrote in 1972 with his co-author A. Douglas Melamed, who is shown on the right. In this article, Calabresi and Melamed define and distinguish between property rules and liability rules as ways of governing legal regimes, as it were, for the distribution and allocation of particular kinds of property rights. So let me talk just a little bit about what Calabresi and Melamed have to say about the concepts of property and liability. The first thing that Calabresi and Melamed do is to expand the notion of property rights, as we've been talking about them, into a slightly larger category, which they identify as entitlements. For Calabresi and Melamed, an entitlement is a legally backed right held by an individual, either to be able to impose specific costs without compensation on other people, or contrarily, to be free of such uncompensated cost imposition. In our steel plant example, we've assumed that the plant's neighbors have an entitlement to their good health. And if the plant takes that entitlement to their good health by tossing crud into the air and forcing the neighbors to breathe that crud to the detriment of their good health, then that entitlement has been taken from the original owners by the steel plant. Alternatively, in principle, the steel plant may have been given a cognate entitlement to impose the cost on the health of its neighbors by throwing crud into the air, and to do so without having to pay any compensation to the plant's neighbors or to win their consent to the detriment of their good health. So, generally speaking, any particular entitlement could be expressed in two alternative ways. It could be an entitlement on the part of some individual to be able to impose costs upon others in a certain way without their consent and without having to pay them compensation. Or a cognate entitlement could be placed in the victims, as it were, of that relationship, and then they would have an entitlement to be free of the specific kinds of costs that are being imposed without their consent and or without their being paid compensation for it. Entitlements, Calabrese and Melamed argue, may be protected in two different ways. By this they mean that the law can throw its weight behind the claims of entitlement owners and protect their ability to enjoy their entitlements in two different ways. One of them is to protect entitlements by property rule, which means that the entitlement can only be transferred from its original owner to another owner if the original owner agrees to the transfer. So in a property rule situation, no entitlements are forcibly or involuntarily extracted from anybody. All entitlements that are successfully protected by property rule, all these entitlements can only be moved from one person to another with the consent of the original owner, which means that the original owner gets to set the price at which the entitlement would be transferred. If I have a property right to my watch and it is protected by a property rule, I don't have to give the watch to anybody if I don't want to, and nobody may take the watch without my consent, but I may sell the watch and agree to transfer it to another person if I'm paid what seems to me by my own lights to be adequate compensation for what I've lost. Or entitlements may be protected by what Calabrese and Melamed call a liability rule. In this case, as in our steel plant example, the entitlement is initially taken from its previous owner without that owner's consent or compensation. But at some later moment in time, the one who has taken that entitlement unlawfully is then required by the law to pay the owner compensation for the loss, and that compensation is determined not by the person who has lost the entitlement, but by a third party. In the case of tort suits, typically that third party is an impartial jury. Thus, liability judgments complete a transaction whose two parts have been broken in time. So we can think about the steel plant and its dealings with the owners of Good Health as a two-sided transaction in which, when we raise the curtain on the problem, only one part of the transaction has been undertaken and the second part of the transaction has not yet been completed. The two parts of the transaction are this. First, the cost imposer initiates the transaction by taking the owner's entitlement without that person's consent. In our example, the first half of the transaction would occur when the steel plant starts to produce steel. It tosses the crud in the air, people breathe the crud, and they begin to suffer deleterious effects to their good health and the costs that are attendant to that. That's the first part of the transaction, and in this part of the transaction, the cost imposer has reached over to the neighbor, to the original entitlement owner, and seized that entitlement from the original owner without paying the owner compensation or without gaining the consent of that particular individual. Where property rules are sufficient to protect entitlements, that is, where people don't steal and where people don't have the ability to simply seize property rights from other people without their consent, in such circumstances, property entitlements may be transferred only by free exchange or by a gift. And when they're transferred by free exchange, as I've noted before, they're transferred at prices that sellers are free to accept or refuse, so that indeed sellers can set their own price, and if they choose not to sell at any given price, then the entitlement will stay with them. This means that the sellers of entitlements can include what might be called subjective values in the price that they demand for the entitlements that they sell. Again, consider my watch. Suppose I'm selling a property entitlement to my watch, and suppose the market value of the watch is $50. That means that I could purchase an identical watch to the one that I have simply by going to the store and paying $50 for it. Now suppose somebody unlawfully takes my watch. Perhaps as a part of an accident, my watch is destroyed, and it's determined that the accident was the fault of someone else. So, in terms of tort liability, that someone else will be said to have unlawfully taken my entitlement to my wristwatch. We might say that the appropriate amount of compensation for me is just the amount that I need to purchase another wristwatch that would exactly replace the one that I had. And by hypothesis, I've said I could go to the jeweler and buy another wristwatch for $50. But suppose this wristwatch was given to me by my favorite Aunt Sally, whom I love dearly, and therefore I place a great deal of sentimental value on this watch. In this case, my watch is not the same as the one that I could replace it with for $50 because that replacement watch didn't come from my Aunt Sally. My watch, the one that I did get from Aunt Sally, has sentimental value to me. Suppose that sentimental value is $100. Then I might be willing to sell the watch for $200 because then I'd receive $200. I'd suffer the loss of the $50 watch that I could replace, and I'd suffer the loss of the $100 worth of sentimental value because I'd no longer have the watch given to me by my Aunt Sally. But that cost, 50 plus 100, is 150, which is smaller than the 200. Alternatively, if I were only offered $50 or $60 for the watch, even though I could get another watch for $50, I'd refuse the bargain because of the subjective $100 value that I attach to the watch. When property rules are sufficient to protect entitlements, I'm free to include these subjective values in the price that I demand in exchange for my consent to surrender my entitlement. But where markets fail, as they did in the case of the steel plant, and entitlements are taken without consent, as the steel plant by hypothesis takes the right to good health, the entitlement to good health of its neighbors, then the taker, in this case the steel plant, extinguishes the entitlement. Once those people breathe the smoke, they no longer have their good health, and their entitlement to good health has been taken from them and effectively destroyed by the steel plant's action of tossing the crud into the air. So, where these markets fail and entitlements are taken without consent, takers extinguish the entitlement, but then, subsequently, in the second half of the transaction, completed in the tort suit, they must pay compensatory liability prices. That is, they must pay damages determined by the jury, an impartial third party, and these prices are typically determined objectively. That is to say, the owner of the entitlement doesn't get to say what the price is. The third party gets to say what the price is, and that's the price that the taker of the entitlement must pay, and it is the sum that the loser of the entitlement must accept, even if that sum is smaller than the amount that the owner of the entitlement would have held out for if there had been a free exchange. And so in my case, a jury, in the case of my watch, might decide to give me only the $50 that compensates me for the market value of my watch without paying me the subjective value that corresponds to the fact that the watch was given to me by my favorite Aunt Sally. So let's get back to the problem of tort liability and talk about some of the characteristics of solving the externality relationship with a tort suit. Again, in the tort suit, the neighbors sue the plant for uncompensated costs A jury fixes compensation, and that compensation is typically the market value, sometimes with an extra added bit, which is generally referred to as pain and suffering, which may represent a jury's attempt to compensate some of the sentimental or similar subjective value that comes along with particular losses. How does this work? Well, if, for example, in our steel plant example, one of the neighbors were to come to court and say, I'm going to sue the steel plant because the steel plant has unlawfully taken my entitlement to my good health. Okay. The suit is joined. The plaintiff, the owner of the good health, brings attorneys. The defense, the steel plant, brings attorneys, and the two issues are litigated. The first issue, of course, is, did the steel plant unlawfully take an entitlement that was previously owned by the plant's neighbor? And if so, then the jury decides what the adequate compensation to be paid by the steel plant to the neighbor for the deprivation of that entitlement will be. How are these values determined? Well, people come to court and they're asked about them. They testify, they're asked questions about what kinds of costs they've suffered, how badly their good health has been affected, what it is that they're no longer able to do as a result of the imposition on their good health, and so on. All of this testimony is taken under oath. We presume people are telling the truth. And if the whole system of fact-finding in the trial works reasonably well, then the tort suit, the tort trial, provides reasonable approximations about the costs imposed, and it does so in a discriminating way. That is to say, if there are two different plant neighbors who mount two different lawsuits against the same steel plant for the taking of their two distinct entitlements to good health, as we've said, one individual may suffer a different cost for the loss of his good health than his neighbor suffers for the loss of her good health, and therefore the appropriate damages to be awarded at the end of a successful tort suit will be different in the two cases. But because individual tort suits give every plaintiff a chance to testify about precisely what costs were in fact borne by this plaintiff at the hands of this defendant, if we assume that that testimony is likely to be close to true and that the jury is good at separating truth from falsity in the testimony, then the tort suit might provide a close approximation of the actual costs that were suffered by the plant's neighbors as they lost their entitlements to their good health to the steel plant. Unfortunately, it's very expensive to operate a tort system, and therefore to operate a tort suit costs a lot of money. So in order to complete the transaction that was begun by the initial tort, by the initial taking of the entitlement by the steel plant, somebody will have to bear a very large cost to mount the trial, to pay for the courtroom, to employ the lawyers and the judges, to pay for the time of the jury, etc. But ideally, if the tort system is working perfectly, it mimics free exchange by requiring tortfeasors, the people who have imposed the costs, to bear the full costs of the torts that they have committed. That is, to compensate directly for the full value of the entitlements that have been taken by them by their tortious activity. Notice once again that such a system will not typically discourage all torts. There will still be torts, there will still be involuntary cost imposition, and there will still be liability payments. But if the liability payments are matched to the costs that have been borne as a result of the loss of entitlement by the plant's neighbors, then the tortfeasor, in this case the steel plant, will only impose those costs which are efficient. That is, it will only take the entitlements that are more valuable to it for producing steel than they are to their original owners for any other purpose. And if that is the case, then the firm will pollute the air, force the crud on the neighbors, take their good health, pay the damages that compensate for the value of the good health, and still feel themselves better off at the end of the day. And if that happens, then the tort is efficient. It pays for itself by producing enough value for the person who is committed to the tort to enable that person to pay the full costs that the tort has imposed and still have a little bit left over. Let me conclude this portion of the lecture, this portion of our discussion of the solutions, by talking about a variant on tort suits, which are class action suits. These are a way to economize on the very high costs of litigating a very large number of individual suits by entitlement owners, all of whose entitlements have been seized in the same way by the same cost imposer. So in our steel plant example, we have a very good candidate for a class action. We have thousands of the plant's neighbors, and if each of them were to sue the steel plant individually, an enormous amount of cost would be incurred so that the same first legal judgment could be rendered over and over and over again in the case of each neighbor. That is, it would be determined in the case of each neighbor over and over again that by doing exactly the same act in the case of each neighbor, the steel plant has taken the entitlement of neighbor 1, it has unlawfully taken the entitlement of neighbor 2, of neighbor 3, of neighbor 4, and so on over the thousands and thousands of neighbors. So, one problem with the individual tort suits is that they are, in a sense, all litigating exactly the same question, which is whether the steel plant, by doing this one act, has simultaneously taken the entitlements of a very large number of its neighbors. The only thing that would differ in the individual tort suits are the amount of judgment that would be imposed on the steel plant in each case to meet the actual damages that were done by the tort to the plant's neighbor. In a class action suit, all of these individual claims are amalgamated into a single claim pursued in the name of the class against the steel firm. One trial is undertaken, and in this one trial, the legal issue, did the steel plant unlawfully take these entitlements? In this one trial, that issue is determined with respect to every member of the class. So, class action suits operate when an entrepreneurial attorney creates the class. That is, in our case, a plaintiff might go to an attorney and say, look, the steel plant has taken my entitlement to good health unlawfully. I'd like to sue. And indeed, I have thousands of neighbors who are in exactly the same situation. Then that attorney, if he or she is entrepreneurially minded, might seek to create a class. That is, a legal entity that includes all of the plant's neighbors, all of whom claim that their entitlements to good health have been taken in exactly the same way, and in this case at exactly the same time, by the single act of the steel plant. That is their common claim. If the suit is successful, then the class wins collective damages that are equal to the estimated sum of all of these individual costs. So if each neighbor suffers $1,000 worth of cost and there are 5,000 neighbors, then there's whatever it is, 50,000 or 500,000 total damages to be paid by the firm, by the steel plant, to pay for the costs of all of the entitlements that it has taken. But of course, where the individual tort suits, which, if they were operating perfectly, in principle would generate payments in total by the steel firm equal to the sum of all of those individual damages, the steel plant would pay a different amount of damages to each individual plaintiff because the value of their claims will all be different, because the value of their good health entitlement will all be different. But in a class action, an estimate must be made of the sum of the value of all of those entitlements, And that sum, of course, can be estimated well or it can be estimated poorly. But then when the damages are paid, the damages must be distributed across the class by the entrepreneur attorney. And of course, the easiest way to divide the damages is to divide them equally. It's very difficult to determine whether individuals ought to be paid a different amount from the large collective damages. That would simply reproduce the problems of the individual tort trials. So one way in which the class action suit economizes is to amalgamate all the claims into one. But a second way in which it economizes is, as it were, to cheat on the distribution of the damages and to divide the damages in such a way that may or may not actually represent for every individual plaintiff the actual amount of the value of the entitlement that that plaintiff has lost. So the class action suit, as an alternative to tort suits, offers lower transactions costs than the tort suits, much lower because we've reduced the number of lawsuits from 50,000, say, to one. But in this one lawsuit, there's a much coarser, much less individuated estimation of the costs that are imposed by the taking of each individual entitlement, and there's a much less discriminating distribution of the liability payment among the various cost bearers, each of whom, as we've seen, may bear a very different cost as a result of the taking of the entitlement. Next time, I'll consider two other solutions to the market failure problem.